personal data enables employees to monitoring work performance as well as maintaining employees' discipline and productivity. The new technology involved includes global positioning system, video surveillance, smart cards, face recognition, and biometrics. The collection of personal data has significant importance of regard to policy. The Malaysian Federal Constitution does not specifically recognize privacy as a fundamental right, while the Personal Data Protection Act 2010 only protected the handling of personal data in commercial transactions. The definition of privacy is widely differentiated according to context and environment, and in most countries, this concept is combining with data protection that interact privacy in terms of management of personal data. Privacy protection is essentially the limit to extent to which society can interfere with one's personal affairs. Privacy is an expectation that personal confidential information disclosed in private place which is not be disclosed to third parties because such disclosure would cause any reasonable embarrassment of emotion stress on a person's sensitivity. The right to privacy is also limited to individuals who are in place that is reasonably private, for example in a home, hotel room, phone booth, and also so on. There is no protection for information whether the information is a public record or the victim is voluntarily disclosed in a public place. The right to privacy is also considered a human right. The Federal Constitution of Malaysia does not specifically recognize the right to privacy, but does provide for a number of related rights, including the rights to personal liberty, the rights to freedom of moving, and the right to freedom of assembly, expression, and association. However, certain restrictions on such right may be imposed by law to protect federal instance and security and maintain public order. In other words, the right granted under the Federal Constitution are not absolute. There are laws that limited the right protected under the Federal Constitution. With regard to employee privacy in the workplace, there are no specific law governing this issue. Former Prime Minister Tun Abdullah Haji Ahmad Badawi in press conference stated that there is no specific law that allows the termination of the contract or service of any civil servant who browse pornographic website using an office computer during working hours. He added that only disciplinary action can be taken against civil servants who misuse office facilities. However, the executive director of the Malaysian Employees Federal, Encik Samsudin Badan, instead that he suggested that employees who browse pornographic websites during official hours should be dismissed of abuse using official facilities. Therefore, action can still be taken against any Malaysian employees who abuse of any office facilities for personal use. In other words, employees are subject to any oversight and monitoring by their employees. However, 38% of employees in Malaysia believe that their data is safe and not misused by their employers. Therefore, a specific law needs to be created to protect the privacy of employees in the workplace. For now, Malaysia still adopts and applies common law to address matters related to employee privacy in the workplace. The Parliament of Malaysia passed the Personal Data Protection Act 2010, which seeks to regulate the collection, processing, and use of personal data by individual or organization in order to provide protection to individuals' personal data. And it established a common set of rules and guidelines to the handling and controlling of personal data by any person or organization. Even with a monitoring policy in place, any employer should expressly state that is not obligated to monitor employee communications. Otherwise, employees may claim that the organization failed to protect them if harmful or offensive conduct occurs and the employers fails to catch intro monitoring. Employers should consider the key provision when developing a company-wide monitoring policy. First, specify what is governed by the monitoring policy, such as electronic communication, telephones, company property and premise, and inform employees that monitoring the searchings and occurs at any time, for any reason, with or without any further notice. Then, establish that the organization computer and phone phones, and other equipment generally are intent of business-related use with a limit amount of personal use being acceptable. Employers should prohibit the transmittal or downloading of material that is offensive, pornographic, obscene, profane, or discriminatory, harassing, insulting, degrading, or otherwise unlawful. Employer also should prohibit the transmittal of dissemination of the company confidential information for trade secret to any outside source. The employer need to explain to employees that all communications and files are subjected to employer monitoring, and that the employer has access to all such files, even those files that the employee has deleted from the system.